Like the red shoelaces, by the way.
Oh, thank you. Thanks for noticing.
Well, good afternoon, and good afternoon to those of us who are joining us on our live stream on Facebook. As most of you know, I spent 25 of my 30 years as a prosecutor handling sex crimes and crimes against children, and that was absolutely my passion in my career. So several years ago, the county attorney's office applied for and received a grant to test untested sexual assault kits. Since that time, a number of similar grants have been awarded to the Maricopa County Attorney's Office, and all total, this community has approximately $8.3 million to test these kits. The primary focus of these grants is to make sure that we can test the backlog of previously unsubmitted sex assault kits that are held by law enforcement in Maricopa County. Altogether, when we started this process, there were approximately 4,500 rape kits held by law enforcement that had not been tested. By early 2020, they were all tested to completion thanks to these grants. The grants were from the District Attorney in New York as well as the Sexual Assault Kit Initiative. The testing has led to 18 defendants being indicted, 16 have been convicted, and there are 2 cases still pending. We are now using the funds to test approximately 1,250 partially tested rape kits for DNA. Let me explain what I mean by that. Partially tested would include kits that were tested under older DNA technology or possibly even serology, meaning blood typing, but they have not been subjected to current DNA type testing. So with those technology advances, there's hope that we can get DNA profiles that would allow us to reopen investigations and possibly lead to prosecutions. We're also focusing our grant resources to assist our law enforcement partners with other cold case, sex-related cases in Maricopa County. We have a SACI investigative team, and they are also using the funds for travel expenses if they need to go, for example, out of state to interview witnesses or other individuals connected with the case. We've also contracted with 6 private vendors to provide any type of advanced DNA or additional DNA testing that law enforcement may need to solve cases. In January of 2020, we extended the use of the Maricopa County Attorney's Office SACI funds to all police agencies within Maricopa County to use in any of their cases, but we've also sought and received approval from SACI to use those funds for any law enforcement agency within the state of Arizona. Up to this point, we have had a total of 31 cold case sexual assault cases approved for the use of our funding for advanced or additional DNA testing. 6 of those cases have been solved with the assistance of SACI funds, and the others are being worked on. We're also using the funds to train. A number of years ago in Arizona, we had an annual sex crimes training, and that has been discontinued. So we have used the funds to put on an annual training for sex crimes detectives, prosecutors, probation officers, and other affiliated professionals. This year marks our 5th annual SACI conference. It's going on as we speak. Just last week was my 30th anniversary as a prosecutor at the Maricopa County Attorney's Office, and I sent out an email to my staff talking about the changes I've seen in those 30 years. Because I am and will always identify as a sex crimes prosecutor, I talked about the changes that I had seen in my time, and these are changes that have been brought about largely, if not entirely, by our office. Looking back when I started, sexual assault of a spouse was a crime separate and apart from sexual assault. Sexual assault was and is a Class 2 felony, which is the 2nd most serious felony that we have in Arizona. But sexual assault of a spouse was a Class 6 felony, the lowest level of felony. Thanks to the efforts of the Maricopa County Attorney's Office and the work by the legislature and then governor, that was taken off of the books. And so sexual assault of anyone now is a Class 2 felony. The rape shield law was not in statute. What that means is the law that prevents victims from being asked personal questions about unrelated sexual activities on their part was not on the books. It is now. There was a statute of limitations of 7 years for molestation and sexual assault. There is now no statute of limitations for either crime. Sexual assault counts could run concurrently. That means that somebody who raped someone repeatedly could receive one sentence that ran at the same time as every other sentence. That is no longer true. Every sexual assault count must run consecutive or stacked on top of every other sexual assault count. Child sex trafficking defendants could not be held accountable if the victim was 15, 16, or 17 years old, unless we could prove beyond a reasonable doubt that the trafficker or the customer knew that the victim was underage. And that was often hard to do. That has been eliminated from the statutes, and now these people can be held accountable, and they are being held accountable. A grandparent who had sex with a grandchild who was 15, 16, or 17 years old was charged with a Class 6 felony. That person is now held accountable with a Class 2 felony. All of that has changed because of the hard work of the prosecutors in this building and the investigative agencies that we partner with, as well as the legislature and the governor's office. And I want to thank everybody that's been involved over the years that I have been able to see so many positive changes for victims in this community. And with that, I'll take questions.
All right. I got a few.
Okay.
Well, let's start with the big news of the day. There are reports now out there released from Attorney General Chris Mays that suggest that former Attorney General Mark Brnovich may have withheld evidence that debunked election conspiracies out there. Now, considering that Maricopa County was kind of ground zero for a lot of that, there's been a lot of angry response coming from Maricopa County elected officials. Just want to get your response to it.
So regarding the report that was in the Washington Post this morning about information that the Attorney General had about the elections, let me start off by saying that I am absolutely committed to election integrity, and I understand that free and fair elections are absolutely critical to the survival of our democracy. As a prosecutor, the integrity of a case depends on the supporting evidence, and that is vital to ensuring justice. I do not predetermine the outcome of a case and then seek evidence to support that outcome. I and we in this building follow the evidence. So given today's media reports about the Attorney General's investigation into the 2020 election, I haven't had time to read them in their entirety, but that said, I do know that there is no evidence presented to date that changes the outcome of the 2020 election in Maricopa County. The impact, however, of the accusations not supported by evidence has cost county taxpayers hundreds of thousands of dollars in litigation. It has also greatly affected the lives of people in our community, including county employees, elected officials, and citizens who have volunteered to ensure that our elections are run fairly and freely.
Yeah, and just follow up. If true, I mean, do you think Mr. Brnovich should be investigated by the bar?
Having not read that, I'm not going to comment on that at this time. I'm certain that that will be looked at.
All right, I need to ask you a couple questions about body cam footage. It says your office has asked that some of the footage be held in certain cases. Now, are there certain cases you would ask for it to be released?
Actually, this office doesn't direct law enforcement on whether to release body cam footage or not, and oftentimes that does happen. But if there are situations where a prosecutor feels that releasing body cam footage would have a detrimental impact on the case because maybe the investigation is ongoing, or it would be detrimental to either a defendant's rights or the victim's rights, we can and have sought court orders to allow the judge to decide whether it's appropriate to withhold body cam footage.
All right, in Phoenix, they have this told they have a practice where they work to release footage in critical incidents within 10 days, but we've also waited as long as 6 months to get some of that footage. Is that an appropriate amount of time?
You're asking me whether it's an appropriate amount of time
Waiting
generically.
6 months, yeah.
I'd have to look at each case. I know that sometimes it is prudent to withhold certain information while an investigation is ongoing, because what you don't want to do is release footage and then interview witnesses about what their memory was, because that could taint, or the argument could be that their memory was tainted. So I can understand that there are reasons for it. I'd have to look at the individual case to talk about whether it would be appropriate for that long in that case.
We should get together like this more often.
Absolutely.
I'll go. I wanted to ask you about fired prosecutor April Sponsel. She was hired by police to train officers how to testify in court. Just wanted to get your take on that.
So the question is about April Sponsel being hired to teach about testimony in court.
April Sponsel, who was fired, being hired by police to train officers how to testify in court. How do you feel about it?
You know, I am the county attorney that terminated April Sponsel. The termination letter has been sought through your public records request, and it's been made public, and it contains the details and the reasons for that termination. I don't want to comment beyond that as far as her activities. It wouldn't be appropriate, but that said, I will say that this office is certainly happy and able to provide training to law enforcement if they wish to have it from us.
Does it worry you that she's now training these officers?
I don't think it would be appropriate for me to comment further. Obviously, I did terminate her from this office.
Thank you.
Is that it?
That's it.
Okay. Have a good afternoon, everybody.